صباح الخير. أسعد الله أوقاتكم.
Good morning. We will continue the session of the important conference in the second day. The second day and the second session. The first session title was the training in the judiciary under the challenges, and we are honored to have as speakers who are three: the Sheikh Dr. Magdi Yaqub Ashur, the academic counselor for the Mufti, and also he have a big stance in science, and he is well known, and we are honored with him, and we will benefit from him and from his attendance. Also, we are happy to have Mr. Mu'assam Shiha, the lawyer in the Court of Appeal, and he is the Secretary General for the Arabian National Council for Human Rights. Yesterday it was the beginning of the conference, and we have a lot of speakers, and we discussed the constitutional rights and the agreement and the correspondence between the Constitution and the criminal laws. We talked about the procedural laws yesterday and how it agree with the Constitution. Also, we discussed also the Egypt commitment for the international agreement that we endorsed, also how the legal frame and the actual implementation of the penalty law with the international obligation of Egypt. Also, we discussed very important part in the end of yesterday, the capital execution and the capital sentence and its critical debate. And we have Dr. Ahmed Mamdouh, and actually the discussion was beneficial, and Dr. Karam Khamis covered the media vision of the capital sentence based on some journals and press analysis. And we have very important meeting with Dr. Ahmed Al-Fai, which discussed the capital sentence in the Egyptian law. And I want to remind the audience that Dr. Ahmed and the audience referred that there are more than 100 penal article in the Egyptian law regarding the capital sentence, so this number is a lot, and there are 153 articles covering the capital sentence. And I think it's a reflect how the judiciary implementation are overusing the capital sentence. Also, yesterday we understand that we should face these challenges, and we should face the phenomenon of overusing and widening the use of the capital sentence. We had a distinctive attendance from the Egyptian parliamentary, as it's the stakeholder of issuing the legislations. And we have a president of a Human Rights Council, and he also discussed the criminal legislation regarding the criminal law. And we had Margaret Azar, the parliamentary, and both of them declared the procedure and the regulation of the parliamentary, and they showed the group of legislation that is prepared in the parliamentary right now. Especially there are amendments that is expected to be issued regarding amending more than 150 articles in the criminal law, and I think it will generally amend the law. We hope it will be satisfying to the community. This was a preview and recap for what happened yesterday, and we will start directly this session with Mr. Ahmed. He will talk about the legislative procedure. I want to draw your attention that we started late because of a lot of absence from the members, but I hope we will try to compromise the time because the chief have another engagement, and we will be honored to listen to him. So I hope the colleagues don't take a lot of time, and I want the audience also to have a concise and brief questions. Okay, thanks, Mr. Mahmoud. The paper is before you. What I mean from it, that generally we have two primary points that created a debate lately. The first part regarding the discussing or draw attention to the capital sentence generally, and the second part about the some participation of the Arabian Association for Human Rights, and referring a suggestion for the High Council for the legislative reform regarding the criminal procedures. The first part regarding the implementation of the capital sentence. Regarding the capital sentence, there is a lot of rights, violation of rights, especially the human rights. Also, it wastes a lot of the guarantees for fair trial. Egypt obligated and committed to the international pact and to protecting the civil and political rights, which guarantee that the high crimes in which we can deprive the perpetrator of their life, and the Arabian Organization for Human Rights and a lot of organization for human rights have a lot of legislation and studies about capital sentence. We think that lately it created concern because of the capital sentence and the intensified courses, and most of it were absent sentence. Despite there are guarantees for the capital sentence in the Egyptian law, but overuse in the capital sentence and also the legislation using this capital, which more than any severe or high crimes, to use a sentence as exception. It's create a doubt and a question and doubt about the justice of the system. Also, there are political and social and emotional effect of the implementation of this sentence. I think the capital sentence is a sentence which we can't reform after we did it. Also, the overuse of this sentence is violation of some international pact, which justify that we should use it in the less and minimum limit. Also, we are referring that there are more than 500 persons have this sentence stay on remand more than 5 years, and it lasts for more than 15 years. And the implementation range is 15% a year, which is show that the state can reform the ratio of implementing and using this sentence annually. Also, some examples in the last years referring to the overuse of the sentence. The capital sentence created a very bad image about Egypt, and most of the sentences were absent sentence, which also hundreds of the perpetrated have a capital sentence are around 600%, and the Court of Appeal appealed this sentence. We see also that the IFTA agency played a very important role to limit the capital sentence. Also, the Mufti opinion stay advisory, but we took his opinion in a lot of cases. Also, it reiterated actually some of the criminal court to use this capital sentence based on the opinion of the Egyptian Mufti religious leader. One of them have a masjid 13 accused were had verdict from Muslim Brotherhood, and the court used the report of the Mufti, and they decreased the sentence for life sentence. Also, the president have right to reduce the use of the capital sentence to allow a time to reform the decision. And one of the accused got a capital sentence. Then the president issued a decision to decrease the sentence to prison. Also, we need a positive attitude to protect the country and the society. Also, it will help the legislative for reform. Also, there are clear expression and statement in international conference and other that we can't accept any political or social pressure to use the law to oppress the sentence in a terror crimes. It was clear that most of the case of the capital sentence was from one circle or other circle, including Armenia, which was suspended. Also, there were any decrease in the defense right or listening to witness and also interfere into the court of appeal is violation. Also, we should restrict it to the primary law for it was clear from the judiciary decision to refuse any amendment in this matter, but also the late amendment was as a suggestion from the parliamentary. We are sure that any way to face any urgent matter should be used by justice, but without pressure from outside factors. And we also respect and protect the human rights also. But what we are seeing in the use and the legislation of this sentence related to emergent circumstances as example for fighting terror can't be the norm. Also, we want the Egyptian legislator to reconsider the legislation that allow the capital sentence and find an alternative for the sentence, or also to know how to limit the sentence which guarantee the justice. And I think finally we can use this sentence because of the current situation. Also, it's a summary part of a suggestion to reform some items of the criminal procedure provided by the Arab Organization for Human Rights as participation to reform the legislation, and we applied it for the High Council for Legislative Amendment in 2017, and also the organization provided a suggestion which was accepted by the member of the expert, and we can refer it after it was reformed to use all these suggestions in the or as a part of a related project. Mr. Mahmoud, yesterday we got a declaration from the Justice Minister for amendment. Somehow we know that some of the amendments have related to our suggestions. The first point we provided in the paper is on remand prison. It's not norm and it's not a reason, but it's for an emergency which as a protective procedure. The law depends on a need but not on the emergency, and the overuse of the on remand is right now as fighting the crime and terror groups is a kind of emergency, and the long-lasting law can't be like that, especially if it's a rolling law like the procedural law. On remand prison as a punishment for the prisoners that didn't get acquitted yet, but taking into consideration the social and economic and condition in the context. The organization suggested that the amendment provide guarantees to limit the use of the on-remand prison in certain circumstances that cope and agree with the reality, and also to prove the availability of accusation evidence and the report of the and also we should find an alternative to use also the forcible attendance in a place or banning the travel in the emergency, and this alternative should have a judicial revision in a reasonable time. Also, we should get back to the law number 83 in 2012, which decreased the on remand time in 2006. The organization said that the procedural law, according to the results and the international experience, is under reform in an interim period, which can't be more than 10 years. Also, we should provide guarantees for the prisoners and reduce the burden caused by it from over the burden shoulder of the witness. The second point, also recompensation if all over the justice system, all the criminal or for other different reason. Discussing about the on-remand prison for itself as a punishment that taken into consideration the various international experiments. Also the recompensation law in Article 54. It's allow the organization to give the prisoners, and also if he could defend himself, that we can do that, or by we should have a guarantees for the recompensation for the on-remand prison, taking into consideration the acquittal decision and taken into consideration the verdict, because the Egyptian fiqh depend 3. The acquittal statement should be published in the Egyptian papers to decrease the moral and emotional punishment. We can also think to have a special fund to settle out the recompensation of this problems, and it will have allotment from the High Council of Judiciary. The private fund can contract with a company in the insurance to provide an insurance or compensation for the prisoner got on remand prison in specific crimes. The third point regarding the authority of investigation, Article 162 and 210 of the Criminal Court ban the use of unless it issued from a crime against the one of the law enforcement individuals, taking into consideration that this ban represents a bias toward the law enforcement officials and to prevent the citizen to use its right to defend himself and have a royal lawyer. Also, the legislator limited this right to law enforcement forces without the victim. That's a waste of the right of the victim, which head to the investigation. So the organization suggested to open the challenge and the order of the investigation, because the lawsuit is invalid, and also the victim should have reconciliation in this case. For the financial guarantee, taken into consideration the implementary expert, if we release the criminal or the accused by a bail, into consideration also the organization suggests to have guarantees to release the accused to agree with the kind of the crime and the evidence and the financial situation. And this topic or point, the response of the specialist or the technical secretary, generally the general secretary, it's stipulated, but they didn't have rules to determine the fund. Listening to the witness, and I want to transfer to the other point. You can't imprison someone. It's not in the procedural law, it's in the criminal law. And to agree with the international standard, also it represents the constitutional and law, and also under the political that we can. The organization suggests to ban the imprison and the registration to provide the amendment in the criminal law and to prevent the freedom restricting sentence that the state will provide directly or through other companies. The second point, speeding the investigation. Yesterday, some of the speakers told that we should determine a time to the verdict. The judge said it will be a waste of the judge timing to rule the case, so we suggested that the judiciary agencies will help the general prosecutor and that which, in case if they will harm the prisoners. Also, these state will pay more. So the organization suggested to have a deadline for to do the job between 20 days in the misdemeanor and 30 days in the big crimes, and you can't prolong the time without a decision from the general prosecutor and with the reasons, and this prolong will be not more than half of the time, which is 10 days in the misdemeanor and 15 days in the crimes. Item 9. Support the right of the defense and the accused. 10. Restrict the ban of traveling. Yesterday, Mr. Magdi said its 11 agencies have authority to ban someone from traveling. So in the emergency and banning the traveling, we want to organize this procedure without failing the justice and without discrimination against the accused. We organize to determine the crimes that will be allowed to ban someone from the traveling. Also, we should inform the accused of their ban in a reasonable period, which is 3 days. We should reform the judiciary of the decision of banning a person from traveling within 10 days, regardless if he challenged or didn't challenge the general prosecution decision. The decision will be automatically issued once automatically cancelled once the general prosecution closed the case. This point, especially, one of the judges attended provided a integrated decision regarding the judicial authority that he want to relate the the criminal procedure to the ID of the Egyptian person. So normally he will know directly if he have a ban of travel decision or not. So once he get on the special website, he will know that, and he will not be surprised like that. And I think the new amendment referred to that there are adoption for this period, this idea. Lately, the organization give some items, and it's mentioned in the paper, and I'm sorry that I took so long. We thank Mr. Ahmed Reda in his good view and his wide point of view about this topic, with it include the idea and the stance of the Arabian Organization for Human Rights in a group of legislation which is criminally General, and he showed the negative sides and positive sides about the legislation and the implementation and the role of the Court of Appeal, and it reflects also how we overuse this sentence and the reflect of that on the current situation of Egypt and Egypt's reputation in the world. Also, he suggested to make the law agree with the constitution, and also he suggested to give compensation for the prolonged on-remand detention. Also, Egypt, now the compensation have a lot of provisions, but we are talking about civil recompensation. Also, he discussed very important point is resuming the orders regarding that the criminal suit can't. The suggestion also discussed the matter of protecting the witness, which we covered yesterday. I think Mr. Ahmed pointed out very important point that the slowness of the litigation, because the late justice is a sentence and sanction or punishment. The victim are paying for that and their people are suffering from that. It's a really crisis in Egypt. We should face it. Mr. Ahmed and the organization pointed out there are a difference between the hastiness and speed. We should be fast but wise and correct and just. The society are pressurizing the judiciary agency to fasten and speed up and reach a verdict, but we hope that it will not lead to hastiness or unrationalized decision in the criminal verdict, because it can waste the right of the fair procedure and fair trial. And he discussed important point, which is phenomenon, and it's across the board, which overuse of the ban of traveling. It's also go hand in hand in money confiscation, and it touch and affected the important international standard, which is the right of freedom and safety of the person. And actually, Mr. Ahmed added very important point, which is Article 2040 in the Egyptian criminal law, talking about the waste crime, which go against Egypt's commitment to the International Pact for the personal rights. Also, I want to add that Article 241 and its agreement with Article 11, there are challenges in the Court of Appeal and Constitutional Court. It's still in the court. It's very important part. Also, the last part that Mr. Ahmed said, the idea of the procedures and how the procedure will be electronic, and I think there is a project in the Justice Ministry that they have initiative in North Court, which will be mechanization of the court or automation of the court. That a lot of courts in Egypt have a paper system, but they want to transfer it to technology. We hope that the Justice Ministry will take fast positive steps to automate the courts. Also, now they are suffering from reading the reports and the cases and the minutes of the courts, because it's still manual, old-fashioned. We hope that we will have fast, quick steps to automate the courts. Thanks, and I think the best thing is the mediation and medium ideas. I think Dr. Magdi Ashur will have the floor. We have a subtitle legislation aiming to protect life, not to waste or restrict it. In the name of the merciful God, thank God and peace upon Prophet Muhammad, our leader and our the right person. I am honored to have you on this session, and I thank the organizer, coordinators of this conference, of this Egyptian workshop, that after all it's give the legislature an idea, it help them, it give them, it aware them, and it's protect their life in the beginning. We have guarantees in the Egyptian legislation. These guarantees protect the right of life for human being. The first guarantee is the terms. The terms in the Egyptian Sharia, we don't know execution or capital sentence, but we know revenge. The word mean that there is a crime committed against a person or family or society. So we will have a revenge, a fair, just revenge from the perpetrator or the offender. So the word of execution doesn't have the equality or fairness, or doesn't convey the idea of the crime, but the word fair revenge or retaliation, fair retaliation, mean that there are a crime and we are making it fair. Second, the Islamic legislation are always honored to protect the human life, and he doesn't want to shed blood through its legislation all over the fields, whether in the especially the criminal legislation, execution or kill or murder. In the case to take to revenge for a murdered person, or to revenge for a society that we are taking revenge from a corrupted person or a corruptive person, that a human being or a group spread corruption all over the country through violence and corruption and rampaging. Maybe in the Egyptian legislation regarding the stoning the adulterer, it aimed to protect the whole human being of the society. We will talk about it, that the legislation aimed to protect the human being. Some scholars in Islam also prioritize protecting the human being above protecting the religion, because the human being is more important than the religion point of views and practices. And God focus with the human being, and any religion or obligation of the religion is invalid or vain without protecting the human being, protecting not only the victim, but we are protecting the whole community. So we are protecting the right of the offender, the murderer, the killer. Also, we protected the right of the victim. So we are protecting the whole society. And so if we take it easy with the murderer, it will happen again, and the murder will prevail on the society. Also, we are discussing how to implement execution and capital sentence. It's appear and clear in the law, and given that the mufti or the religious leader have a advisory opinion, but he have a law or legislative point of view and background. When they asked him about this matter, they take his point, because he is the last step or the highest stand in the capital sentence. When the when the case are referred to the Mufti have very important role. He said that any any doubt can repeal the punishment. Also, within the arrestment procedure, in the case it can repeal and cancel or demolish the punishment. And Al-Mufti tell us and declare it to the court to protect the life of the human being. If even he committed a crime, this important guarantee which doubt can repeal the crimes is very important. So it allow the Mufti the place or decision that if he found someone will be executed, he can save him by the doubts or misunderstanding or confusion. He can decrease the sentence to life sentence. But we also should notice that there is big problem that the capital sentence law, when it was existed 10 years ago. No, we were talking 10 years ago to demolish the capital sentence or restrict it. We should taking into consideration that the terror prevail and propaganda for the capital sentence and the revenge idea. So there are some suggestions wanting to use it to restrict or decrease the use of the capital sentence first. And it's a place, I think it's not a legal affair, but I think it's social affair. We should fight terrorism. That's mean human being can't reach a terror state in which he move with arms and killing people and taking life. We should stop this terrorism before it's reached the human being. So, what are the meaning of the terrorism? Does terrorism have a 1 degree? When we talk about for example, in the Egyptian IFTA agency, when we answer for the terrorist ideas, we are differentiating between the extremist and terrorist and the old-fashioned people. If we determine the actual meaning of terrorism, I think a lot of people can't be terrorists, and a lot of people will not deserve revenge because they just have old-fashioned ideas, and they are not murderers. So now we can spare and protect a big group from the capital sentence. Also, we should enforce the idea of solidarity and normalization and coexistence. There are laws that identify the meaning of coexistence, and if people go against the law of the coexistence, they can be punished to avoid discrimination, which lead to terrorist activities. So people will bloodshed, whether it's in Egypt or in the Arab countries. So if we provided the idea of coexistence, we can protect our people and the Arab countries, and we can also decrease the use of the capital sentence. Also, to decrease it, we should commit the just to refer these criminals for the. We should refer it to rehabilitation and mental asylums, not prisoners. So the people also, we should face the sexual harassment and the law ruling that to prevent, and I mean this is a preventing procedures or protective procedures. Working in the sexual harassment phenomenon, we need a strong law to protect the honor of the people. Also, we should have awareness and educating the people to know that this act violates all the Arabian and Islamic rules and culture. So we widen the gap between the sexual harassment and the rape crime that's also we need to a legislation and helping that to fight terror, and because it leads to discrimination and fight with each other and kill the people, and it will lead, I am not specifying a specific religion, because I disagree that a terrorist coming from Islam or blaming even Islam for that, because Prophet Muhammad have been sent by God just for mercy for all the world, not only the Muslim. So when we issue a law to fight hatred and religion scorn, I think it will fight terrorism and extremism, and it will prevent the human being from holding weapon to murder or kill other one, and can. So bottom line, we need education, we need awareness, and we need also a protective laws to prevent the crimes leading to capital sentence. This matters, these primary procedures are a lot, and we can do it in various fields, and we can use also the National Council for Research in the social and criminal side, which will help us to detect the phenomenon and the social sides that lead the human being to commit the crime. Then he will have a capital sentence. Finally, but not least, we hope the best for you and the success in this workshop. This workshop will lead to protect the human being, not only the human being, but also to protect the mentality, the mind, the honor, the dignity of the human being, along with his freedom. This is one of the ABC of the Egyptian Sharia, and thanks a lot.
الشيخ، والحقيقة أنا رأيي يعني الشخصي نحن أمام يعني قامة جليلة، قامة للاستدارة والوسطية، تناولت الموضوع الحقيقة من
Thank you, Mr. Sheikh. Many topics have been discussed, and the role of moderation in Islam, and especially in any topics, especially when it's a specialized legal topic. And His Excellency, the Sheikh, has dealt with a number of issues. First of all, he has been talking about the role of the Mufti as an advisory or a consultative role concerning the death penalty, yet it's not binding, of course, to the court. But as a lawyer, I am kindly asking the Sheikh to tell us something about that the opinions of His Eminence, the Mufti, are not always published, even if they are not advisory, yet they are important for the law professionals, especially when it's related to His Excellency the Mufti. And we'd like to know, even if it is not accepted by the judge, but we want them to be published in order to know the opinions. So as a lawyer, I'm keen on reading all these opinions of the Mufti to understand the religious background behind it. Also, His Excellency the Sheikh has also been discussing a number of problems related to the doubt. And what's important, as I said, that the accused is always innocent unless proven guilty. And the role of the mufti is not only from a Sharia point of view or from a legitimate point of view, but also through procedural roles. And the prosecution in general, the role especially related to arrest, related to investigation, is an important guarantee for the accused. His Excellency the Sheikh has said the components of how to make an advisory or a consultative opinion. Also, his Eminence the Sheikh has stress the importance and the main goals of Islamic Sharia law, that is to protect the self of the human being. And also he has dealt with a number of basic terminology related to the difference between death penalty or execution, or i'dam in Arabic as a term, and also qasas or retaliation as a term, also to keeping the self or keeping the human being in society. This is important to differentiate between the two terms, death penalty, i'dam, or other point is qasas or retaliation. But both aim at preserving the safety of the people. And the next session we will have a discussion with Dr. Adil Medani, a professor in psychology, about this. As I said, and as the Sheikh said, the main goals of religion is to keep the self, to keep the mind, to keep the spirit of the people. The Sheikh has also stressed the importance of keeping the lives of the victims. When we talk about the death penalty, when we talk about the guarantees, when we talk about how to keep the rights of the accused, and His Excellency, as one of the goals, is to preserve the self and the rights of the victims, which does not contradict with international standards, charters, and international laws. And therefore, transitional justice, which is one of the main important UN principles, will be achieved, as I said, which preserve the self and preserve the victim's life. He has also provided a number of proposals, especially related to the establishment of an anti-terrorism unit, that is the prevention against terrorism. We always deal with the terrorism from not only through explosions and murders, but also to prevent terrorists and to face the extremist ideas. This is another angle, not only about the killing and the murder, but about the extremist activities. Also, the Sheikh has been clarifying the point of the drug traffickers, and he proposed them to be put in sometimes rehabilitation houses and asylums, and not to severely punish them, which also commensurates with the modern philosophy of criminology and criminal philology in the modern age, that is the so-called alternative punishments, which is, of course, important for to avoid other hard punishments. Also, when he talks about sexual harassment, and he said that it needs another punishment. Also, he discussed the role of hatred and how to overcome hatred and how to get over the grudge between the people, and how to have a discourse that would evade hatred, that would eradicate hatred from the society. And also, he has discussed the roles of the state, the role of the religious people, the role of the society at large. And I think that in facing terrorism and facing death penalty, that is the summary of what His Eminence Sheikh Magdi Ashur has been discussing. And now to the intervention of His Excellency Mr. Assam Shiha, Secretary General and lawyer at the Court of Cassation for the Egyptian National Organization for Human Rights. Thank you, Mr. Mahmoud. Now, the main idea which I was discussing is the current parliament in Egypt has promised all Egyptians, after the constitution of 2014, that the Egyptian state has had a strong political will to change a large package of legislations. Then the parliament has already started in the last couple of on the first couple of weeks after being elected and sworn in, that they have accepted and ratified around 150 legislations. And then hopes were sky high that the parliament would change the package of legislations. I think we have hundreds and thousands of legislations that need to be redrafted and reformulated. Since the problem that faces Egyptian legislations is the fact that some amendments have even increased or outnumbered the whole articles of the law. Therefore, the principles of law state that, first of all, we begin with the philosophy, but it is illogical that the amendments exceed the number of articles in a specific law, don't they? Number two, the agenda of the parliament has a bulk of legislations, yet some of them are amended quickly and in an unjustifiable, speedy way, and others, of course, are not looked into by the parliament and are not investigated by the parliament, and they will be behind closed doors and they are not seen by them, especially those related to transitional justice. Today, I have read a published interview with the former Minister of Information, and there was a big coalition in the parliament that they claim that they are not going to form or draft the transition justice law currently, as the Egyptian people reject reconciliation, because Egyptian people do not accept reconciliation with the Muslim Brotherhood or what they claim to be terrorists. I mean the parliamentarians. The second point is the strong political will of the state, but it's frankly important to say that we have yet to reach a strong community will, especially when tackling the point of death penalty. Here, the role of media is of paramount importance, as media were able to convince a large segment of Egyptian society that we have to speed up the death penalty, which of course against all international laws and against constitutions, and to resort to the maximum penalty or to the maximum punishment in any crime that is being published in the media. Sometimes there are very provocative crimes, for example, the rape of a 2-year-old child, for example, or the murder of somebody, and then the demolition and the defamation of the body of the person. This is, of course, the deformation of the body. This is, of course, very difficult for the Egyptian people. Also, we need a very strong, not only state political will, but community will, in order to prepare the public opinion to accept all that is related to death penalty, commutation, or etc. Now, when we discuss the Egyptian Constitution, Article 2, that is the Sharia law, is the main source of legislation. Of course, when we take into consideration the parliament, it is not isolated from society. They may have their own ideology, but before society, they cannot do that. Of course, as we have many civil organizations, NGOs, and who have the big role to play with the Egyptian society and to prepare it for that accepting of death penalty or not. Now, number 4, when we discuss the philosophy of punitive sanctions or punishments in Egypt, we see the legislature in Egypt is trying to draft new laws that reduce the restricting laws for the human being's freedom. And this is thanks to the 2011 revolution, because when the judiciary tried to track down the money or the funds that have been taken by the old regime characters and figures, it was found to be very difficult to take them to justice, and it would have been very difficult to confiscate this money. And therefore, Article 18 of the illicit gains has has been amended to accept reconciliation if somebody has extorted the public funds and voluntarily accepts to return the money back. This article has to be taken into consideration, because even if you apply it to the regime, but you have also given an incentive to the public, for example, now a public figure in the state, if he has extorted or taken money and taken bribe, he would now come to the court and to pay the money back and then have the reconciliation. In the last few weeks, the parliament and the government have been audacious enough and have introduced new amendments to the penal criminal code. I think they are reforms, but they will show us how conflicting and how inconsistent the parliament and its legislative agenda, especially of the parliament and the government. Why? Because they have amended the texts of some criminal articles, and after they have been promulgated in the official gazette, they were a new law introduced to change some procedural articles. That in itself, in addition to the slowdown of litigation procedures, which is one of the main features, I'm sorry to say, of the Egyptian judicial system nowadays, have determined a number of frameworks. The first related to the Court of Cassation. The Court of Cassation is a court of law to which a number of lawsuits are being introduced when the challenge or the appeal is accepted from the form, in form and in content. It will be referred once again to the appeal court in order to consider the case or the lawsuits. What is ironical, or what's good now, is now the Court of Cassation can now deal with the case in order to solve any loopholes, if any. Yet, on the other hand, we have to know that the number of judges at the Court of Cassation is very low. Is it logical to send them all this bulk and large number of cases with a few numbers? Will they be able to deal with all this large number of lawsuits? The third point is that the new law has given the right to the criminal court to accept or not to hear the witnesses and to be adequate, or to just stick to the other evidence rather than listening or not listening to the witnesses. In some cases, as a criminal lawyer, sometimes you have a witness that is the main proof of acquittance for somebody. Therefore, we need to strike a balance. As legal advisors, law shall not be taken to the letter, but it shall be taken to the letter and the spirit of law. Last week, I had attended a session where 4 people were murdered and 12 others had been injured, and the judge has listened to us and then decided at the end of the session. The third point, which is related to public funds, it has been allowed for the criminal lawyers to attend with a private proxy, especially for those people, to tell him, you will not attend to the court. A businessman has a big advantage when not appearing before the court and not into the cage, and he will have a special or private proxy for a lawyer to attend instead of him. In Damanhur court 2 days ago, it was seen that the amendments, in spite of their added value, yet they are doubted to be unconstitutional. Then, when a lawyer, for example, sees that somebody is being punished before the criminal court, when the punishment would be a death penalty, and then by a private proxy he attends, for example, in criminal courts, it's ironical that in a misdemeanor the accused have to attend and does not have to attend in felonies and other criminal cases. We need a comprehensive and strong system that would help us to curb the restricting punishment, or the restricting of freedom punishments. Now, some fierce criticisms have been directed to some death penalty sentences. Yet some people may forget that though we have condemned the collective death penalties, but they were in absentia, and people should know, and I want to know your opinion about that, that these death penalties in absentia are of no value, because when he appear before the court or prosecution afterwards, he will be retried once again. The collective death penalties in absentia are null and void, are in fact meaningless, because when he appears to the court, there will be something else and will be retried. But we are trying to catch our mistakes, and we say, yes, hundreds of death penalties have been made and have been given by the judge, but we in fact fully understand that this works as a deterrent or as something to show before the media. The last point I would like to raise is the fact that the Egyptian government and parliament are always declaring that Egypt is strictly committed to the international conventions to which Egypt is a signatory and party. We hope that this commitment would not be just for the media, but would be a true commitment, and to have the Egyptian people as an agent, not as an object. And as we have seen that there are in many penalties, for example, now look like fines rather than restricting punishments, restricting for the freedom punishments. The last point concerning death penalty is death penalty. I'm sorry when I say that death penalty is a punishment that cannot be overstated. Therefore, a number of guarantees have been set in order to strictly avoid the implementation of the death penalty. It's in the first case, the Court of Cassation, when considering the case, should get it back to the criminal court, and maybe the criminal court will take the decision to the death penalty, and it will be referred once back again to the Court of Cassation, who will finally take the decision. Therefore, it's not a simple procedure. As we can see, we have a case that continued for around 5 years in order for the court to be sure and fully convicted that the person is guilty, and then he receives the death penalty. Sometimes we have seen the accused himself calling for himself to be executed. In some cases this happened. But in the Egyptian society, for those working in civil society, are against the expansion and enlarging the death penalty, because if we are working seriously on the story, we see in the Egyptian legislations we have 5 crimes that deserve or are entitled to death penalty, yet in the law we have over 55 legislations that would allow for the death penalty, yet they are inapplicable. Thank you, Mr. Mahmoud. Thank you, Mr. Isam Shiha, as he has pointed out the mechanism of the legislation or legislative procedure and process in Egypt, and in its final form, as it expresses a political will, and it's important to express a community will as well. He has also pointed out that we have a bulk of legislations in a way that are incomprehensible, that are maybe conflicting, and many amendments are needed. Take, for example, Article 25 of Egyptian procedural law. We have 5 amendments and 3 verdicts by the Supreme Constitutional Court that of unconstitutionality. This is just one article. Article 25, 5 amendments and 3 verdicts of unconstitutionality. Mr. Isam Shiha, has explained the mechanism of legislations in Egypt, And he pointed out that the legislation sometimes is under the pressure of the public opinion and under the pressure of the media, which is very grave and very dangerous. Therefore, the parliament, can listen to the media, can accept the public opinion, yet they have to take their own decision. Mr. Assam also has talked about the second article of the Egyptian law of Constitution of 2014 as the Islamic Sharia law is the main source. In the past, before 1980, it was it was main source or a main source. Now it has become the main source of legislation. It was made as a type of political deal between President Sadat and the Muslim Brotherhood. But now we are talking about the difference between the article the and the indefinite or an. How they make the difference. The main source and a main source. Now back to the legal procedures. We are talking about the conflicting legislations without which society could have been better. What would have happened should the amendments have been delayed for some time? And Mr. Assam also has talked about the impact of this to change the role of the Court of Cassation from a historic legal court in order to be a topic court or a content court. This is not, of course, acceptable according to Mr. Assam. But I disagree with what he said about the death penalty and the enlarging and expansion of death penalty, as there is no legal impact on the Egyptian society. I have a different point of view, but I'm not going to impinge or to encroach on the rights of other people as a chairman. But now let's directly move to other interventions. And I hope that the interventions would be very clear. I hope that everybody would introduce himself, and we hope to have a minute intervention for every person, as we have started an hour late. I hope to be to the point, short and accurate, and within 1 minute. Now we start from the right. Good morning. Dalia Hassan Abdeen, Human Rights Committee, MA in Legal Research. I am responsible for receiving complaints of Egyptian citizens in Human Rights Committee and coordination with the ministries. In fact, Mr. Assam Shiha and His Eminence the Sheikh have raised a very important point. When we deal with legislations or when we act a law, we should not think about the rights of the criminals, but we have to think about those who are being crimed against, the victimized, not only the victimizer. Therefore, we know that we have international conventions we have to abide by, yet we have some problems. For example, the rape of a child who was raped, and the court was unable to make a decision. He was helpless, though the girl, the child was raped by a juvenile who was few months less than the age of 18, and the court stood helpless to apply the law. Now, there are many amendments that need to be implemented, and sometimes qasas or retaliation is not possible due to some legal restrictions, some international conventions. Also, the guarantee, the financial guarantee. In the committee, we have been looking for something to replace arbitrary detention. That is, we have, as you know, we have different legal positions, and we may be conflicted with an article in the Constitution related to discrimination. Therefore, we have suspended this discussion in order to see the new draft law in a way that would not conflict with an important constitutional article related to discrimination. Therefore, people need to be in the same legal positions in order to avoid the so-called discrimination or unconstitutionality. Mr. Shaban Shalabi, lawyer. As far as the death penalty and the opinion of the Mufti of Egypt before taking the decision and before giving the sentence of death penalty, and his opinion is advisory, that is not binding to the court. If I change the nature and I take the opinion of the Mufti as an expert opinion or a technical point and as binding to the court, it will have a different point of view. If the Shari or the Sharia or the Islamic law has decided that somebody needs to be executed, it must be binding to the court. If not, it also must be binding to the court to accept or to refuse based on the Islamic point of view. Yet the right to life is important. It has been endowed and given by God, and it must not be taken unless based on what God has decided in his book. Therefore, the Islamic Sharia law is very important, whether to apply death penalty or not, to be binding to the court. The second point is to stop somebody from traveling. In my opinion, this is not a punishment. If we take it as a sanction to be appealed against, we may make this speedy sentences about this, because sometimes when you take it to the courts, it will take long time to the administrative court and supreme administrative court. He needed to have a quick appeal for it to shorten the time. Now, Mr. Muhammad Khalil, a journalist. I am now greeting Mr. Dr. Magdi when he has talked about the importance of establishing a terrorism commission. And terrorism and murder have nothing to do with Islam. And therefore, we have to raise the awareness of the youth. We have to ask the youth for to avoid this terrorism, because it's not in Islam. It has nothing to do with Islam. As far as transitional justice, to which Mr. Isam has referred, I think the old programs of dialogue is calling for a vicious circle of violence. And there are people who benefit or are beneficiaries from this violence. Of course, the only outlet or exit is the transitional justice. And let's take South Africa as an example, the apartheid of South Africa, when they used transitional justice, period. When transitional justice is meant, we find so many beneficiaries are against and opposed to this due to their main personal and interests. Mr. Mamdouh Muhammad, a social worker at Al-Azhar, a PhD applicant in comparative philology and education. I am quite delighted with the attendance of Mr. Magdi Ashur, and I'm very proud of his contributions. What he said today is an added value, and most of it was very new for me. And I hope that his speech today would be posted on the YouTube and other social networks. And my question to Mr. Isam Shiha is, you have been talking about the guarantees of the ordinary legislations as a hindrance for the justice. How about military courts, where there is no chances for appeal or cassation? What can we do? Are there any amendments that would force or would allow the military prosecution to have different views? Thank you for these interventions, which are very fruitful and rich, and comments from the attendants here. I'm delighted to all the attendees. We have benefited from this discussion. I hope that God would help us, and I thank very much for every person. referring the to the military, also to the Mufti, needs a legislation which is unfortunately there. We abide by the law. We can do nothing about the military prosecution. Now, the first remark of Mr. Mahmoud, the social worker, who was surprised today, or who was amazed today by what he heard from Mr. Sheikh today. I hope that what Sheikh here is His Eminence Sheikh Asur sure today would be also transformed or transferred as a science to his friends, to his students, to all Azharite people. We hope that the graduates of Al-Azhar who sometimes study something, listen to something, and then when they go to the media they will hear something else, which makes a conflict for them. Yet when we want to have great figures of Al-Azhar, like the former Imams of Muhammad Abdu, Rifa'at Tahtawi, famous Azhar Islamic scholars, we need to have an enlightening movement. We need to have an enlightening movement. The second point is about the legal positions. When we take it according to the Constitution, we will have 90% of the laws be enacted or be unable to be drafted and formulated. But hopes are there to unite laws, and the law itself will be not biased and will be neutral. Therefore, the nature of laws need to be neutral and not biased. Thank you, Mr. Ahmed, because he has saved his time for us. Excuse me, could you just ask him to use the microphone? I can't hear what he's... Yes. She wants to know the response about something. I'm not talking about the question. I'm talking about dealing with the opinion of the Mufti as a purely technical expert point of view that is binding to the court. He's repeating what he said. There is another legal problem. If we deal with the opinion of the Mufti, whether it is optional or compulsory and binding, the Court of Cassation has a point of view that the Court of the Content has the discretion to accept or to reject it. Any report or any technical report, it is left to the discretion of the court. Whether it's a Mufti report, whether it's a medical report, whether it's any technical report. It's left to the discretion of the court. This is the case in France and Egypt. I'm sorry, thank you very much for this, and would like to thank Mr. Ahmed and Mr. Isam and His Eminence Sheikh Magdi Ashur, and we will have a break that is 10-minute break in order to begin the second session.